Hello, this is Mario Joyner, your Las Vegas probate specialist. Thanks for watching today. First of all, I welcome you back for another video. I attempt to base my videos on personal experiences, questions from prospective or current clients, and or just practical information that will make the probate process easier while providing the best information possible. Today, I will share a question that I received from a prospective client who contacted me because they were interested in selling a property for a deceased family member. They wanted to know how to sell the property, although the owner of record was deceased and had been for some time. I proceeded to ask a lot of discovery questions beyond just the obvious questions about the property and the like. I wanted to know how long the deceased had been passed away, was there a will left, who was to inherit the property upon death, were they aware of any unrecorded quitclaim deeds, and many more questions, but those are just a few for background purposes. They answered those questions and more, and I mentioned the following, and it will become the basis for the remainder of this video. Probate deadlines. Are there deadlines or statutes of limitations to open probate? And once probate is open, do I need to be aware of any deadlines? Both questions and more will be discussed in this video. So without further ado, here we go. In Nevada, there is no time limit or statute of limitations to do a probate, but I have a warning to share. If a person is claiming under a will and this person would get a smaller amount or nothing in the absence of the will, failure to timely file the will, which is typically within 30 days after death, could cause a probate to proceed under the law providing for who gets what when there is no will. So pay attention to that. Let's consider some examples in which a probate might be done many years after a person dies. Suppose a husband owns a house in his own name, or suppose by some screw up the house is titled to him and his wife as tenants in common instead of joint tenants. He dies, wife continues to live in the house and pays the mortgage, taxes, HOA fees if there were any, and keeps up the property so that no governmental agency issues citations. No one interferes with her occupation of the house. Then the wife dies 20 years later. Now there will have to be a probate involving the long dead husband along with a probate involving the wife's property. In the example mentioned, it would appear that the wife got away with not doing a probate on her husband's estate for 20 years. However, if she had insurance on the house and had to make a claim for damages, she might have had her claim denied since the policy would be in the name of the husband and he's obviously no longer living and around to make that claim. Another reason for doing a probate years after a person has died is that an asset might not be discovered until years after the death. For example, a man or woman had a savings account, dies, and the account just sits in the bank with none of the heirs knowing about it. That could be a reason as well. Now, however, there are usually practical reasons to do a probate fairly promptly. Heirs may want to get financial assets that have to go through probate. In the scenario I mentioned earlier of the wife living in the husband's house after his death, suppose there is an accidental fire that destroys the house. Even if the wife has paid the annual insurance premiums addressed to her dead husband, the insurance company may balk at paying the claim since the dead husband, not the wife, is the actual insured. Or suppose the decedent left only a parcel of real estate that isn't worth much and none of the heirs show any interest in the real estate. Of course, every year taxes will become due, and if no one pays the taxes, the real estate will eventually be sold for the taxes due. Another issue arises if the person most entitled to begin the probate process never gets around to beginning the probate. In that case, another heir could petition the court to act as the personal representative. Here's my second warning for you about delaying the probate process. It is entirely possible for a stranger sometimes to start a probate. This is done because a lawyer or a realtor is looking to make a fee, or a creditor is looking to get paid. Clients have called me about this situation on a couple of different occasions, so I just want to make sure you're aware of that. Are there deadlines once a probate petition has been filed and a personal representative has been appointed? Absolutely yes. Here are some of the deadlines to be aware of. Deadlines to file claims against the estate. The personal representative of the estate in Nevada summary and general probate administrations is required to mail notices to all people known to have a potential claim against the estate if the personal representative wants to take advantage of the deadlines. In the case of summary administration, currently for estates not worth more than $300,000, a notice to creditors must be published in a local newspaper, and creditors will have 60 days from the date of either the first mailed notice or first publication date to file a creditor's claim with the court against the estate. Failure to meet this deadline means their claim is lost. And if the person representative intended to pay a creditor's claim, mail a notice is not necessary. There are various deadlines to know in the probate process, and here are just a few more to know. Letters of administration and letters testamentary expire. To withdraw a decedent's money from a financial institution, the financial institution usually demands certified copies of the death certificate, the order appointing the executor or administrator, and the letters testamentary or letters of administration. Many financial institutions will not honor certified copies of the order and letters which have been certified by the probate court more than 6 months earlier. So, if the administrator or executor waits too long to collect financial accounts, new certified copies of the letters and order will have to be obtained. In Clark County, this process can easily take a couple weeks, as the court will not instantaneously issue those documents. Federal tax deadlines. After a person dies, it may be necessary to file a decedent's tax return for the year the person died and to file any prior year tax returns. If the estate earns more than $600 in any given calendar year, it may be necessary to file an estate income tax return. Failure to comply with federal tax deadlines could result in penalties and interest charges. Insurance deadlines. Suppose a person who is living in their own home dies, and after the person dies, the heirs leave the house empty. There is probably fire and casualty insurance on the house. From the insurance company's viewpoint, an empty house is a bigger risk than an occupied house. Or suppose that after the person dies, the heirs, before the probate process is complete, rent the house to tenants. Again, from the insurance company's viewpoint, an owner-occupied house may be less of a risk than a tenant-occupied house. Now, if a person dies and 2 days later the house burns down, the insurance company is not going to get away with denying coverage. But if the house sits empty for a year and then burns down, the insurance company may get out of paying the claim. Therefore, the heirs should immediately notify the insurance company of any change of status with respect to the house. While this could result in an increase in insurance rates or even cancellation and the need to obtain different insurance, it is worthwhile to do this. Make sure that's an important side note there. So in conclusion, I've shared examples of the circumstances where probate had not been initiated. I explained why it would be necessary to establish probate in order to facilitate a need. And lastly, some of the deadlines in regards to probate. It is such an involved topic and largely specific for each person. Remember, I'm always available to discuss your individual situation or offer referral to the appropriate team member. If you would like access to the best probate information for anyone currently in the probate process, please visit probatetreasurechest.com and get this free information. Until next time, this is Mario Joyner, your Las Vegas probate specialist, real estate, and more. Have a great day.